To order at 6:02 PM. Clerk, please call the roll.
Yes.
Yes.
Present.
Present. Here.
Here. Thank you. And as standard, Maxie, if you can lead us in the Pledge of Allegiance.
This weekend, I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All righty. You'll have to bear with me. I think I'm going to stick to the script today.
Script?
I know. I've got several scripts.
Wow.
Okay, so I'd like the board members to introduce themselves just to make sure I have everyone. Oh, I guess I can start with Howard Nelson, of course.
Hi, I'm Howard Nelson.
He is the Howard Nelson,
Hi, I'm Bob Wolf, not Howard Nelson.
not Howard Nelson.
Not Howard Nelson, but you're my idol.
I am not Howard Nelson.
The new guy,
I'm the new guy. I'm Bill Kent.
Blaise McGinley, chair.
Howard Elfman, not to be confused with Howard Nelson, vice chair.
Good evening. I'm Chad Maxey. Welcome to everybody who showed up today.
Thanks. Mohammed, would you mind introducing the staff?
Yes, good afternoon, Chair and board members. Bert Ford over here to my right, the zoning chief, and have James Hollingworth. He's the plans examiner, and we have Sheila over there, and we have Jasmine in the back from our office, and we have our esteemed city attorney over here, assistant city attorney, Mr. Spence.
So has everybody had the opportunity to review the minutes from last month's meetings? Does anyone have any changes to the minutes? I'll
Chairman, I would
entertain a
move approval of last month's minutes.
Second.
motion. All in favor?
Aye.
All opposed? Passes. Okay, all persons who wish to speak to the board today must be sworn in. Please raise your right hand and be sworn in. If you plan to speak at
Stand.
all.
Stand, please. And your right hand, not your left. Do you swear or affirm any testimony you give at this public hearing will be truthful and accurate? Say yes, thanks.
All righty, just a little general info. Each member of the public that wishes to speak on any item will have a length of time not to exceed 3 minutes per item. Representative of associations will have 5 minutes. I guess if there aren't any questions, I'll call the first case.
Mr. Chair, can we clarify for the applicants? It appears that we only have 6 versus our normal full board, correct?
I think 6.
Okay.
I think 6 is fine. Mr. Nelson,
But what's the vote to pass in a 6 person quorum?
you need 4, correct? Plus 1, so 5.
5, correct.
And Mr. Nelson, do you?
I have a conflict with item number 1. I'll go fill out a conflict sheet.
Chair?
So that is 5.
That means that's
So,
unanimous.
yeah, so it'll have to be unanimous?
Unanimous.
Correct, yeah.
So,
That's what I'm getting at.
well, no, that's a good point.
On this particular item that,
Oh, you're just messing with me.
no, right. On this particular item, it would be all 5 remaining members of the board that have not recused themselves would have to vote affirmatively in the direction of the board's vote for it to be effective.
And that is in reference to the first case item from Lennar Homes?
That's correct.
And so even though it had already been deferred from October 12th, should we give them an opportunity to defer it again to look for a full board, or would that even be a possibility?
The deferral is at the discretion of the board if the applicant is requesting it.
Request. I just wanted to make sure I offered it to the applicant.
Who's all here for that?
If we can,
So all these folks are here for the agenda item.
Well, it's one of the two. It's probably the second.
Got it. Good evening, Dina Gray, land use attorney for the applicant Lennar. It's my understanding, if I heard correctly, it would need a unanimous vote because of the recusal. So we would request a deferral. Unfortunately, we would have to request a deferral.
That's fine. And so, Dwayne, so would one of the board members make a motion for deferral and then we'd vote on it? Now that it's been requested by the applicant?
Is that in order, Mr. Chair?
I'm asking if that's the proper
yes,
process.
that would be in order.
Mr. Chair, I move to defer this agenda item till next meeting.
Mr. Chair, I second.
Was that seconded?
Yes,
For-
You had 2 seconds.
And for the record, because the applicant is requesting the deferral, that you're also again waiving the statutory requirements with regards to the issuance of development permits within,
Yes.
thank you.
Thank you. So do we take the roll? Or is that just
Yes.
pass on a?
Yes, go ahead.
Oh, we can do a voice on a deferral? Is everyone ready?
Chair.
All those who,
Chair. Chair McGlynn, did you do disclosures yet?
no, I did not.
This is a procedural motion, so you don't need to make disclosures at this time.
Now you guys are messing with me. Okay, so what we'll do is we'll do a voice vote, and then since you guys are ready, all those in favor of deferring case number PLN BOA 220700001 to the January, do we have a date? The January 11th meeting. All those in favor say aye.
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 All those opposed? Motion passes. Defer to next month.
Thank you. Have a good evening.
Thank you.
Thank you, counsel.
That was easy enough. All right, so we only have one other one. Give me 1 second. I'd like to call, Howard's back. I'd like to call case number PLN BOA 220800005. I'd like to ask for disclosures, starting with Howard Nelson.
Conversation with counsel and a, for lack of a better term, drive-by.
I had a conversation with the council this afternoon, plus City Commissioner Glassman, and I did my due diligence on aerial maps.
And that's Member Wolf. Members, if you would state your name just for the recording. So
Yeah,
that's-
this is Bob Wolf. Had just notified I had a discussion with council, Commissioner Steve Glassman today, and I didn't do a physical drive-by, but I studied aerials, maps, property maps.
And I did,
Bill,
Are you
Bill,
on your mic?
name for the record.
how do you do it?
Is it on? It's hard to see the light. Yeah, it's on. You
Oh,
gotta
it's already
give
on.
it a yell.
I did talk to the council today about.
Bill, name for the record.
My name's William Kent, and I did talk to her today about it.
Member, if you can bring the mic a little closer to your voice, for some reason the audio is not being picked up.
My name is William Kent,
There you go.
and I did talk to the council today about the issue.
Perfect. Blaise McGinley, I spoke with the applicant and visited the site a couple months ago.
Howard Elfman spoke to council before the last couple deferrals and also did a drive-by when it previously came up in front of us.
Chad Maxey spoke to applicant's counsel in the previous iteration and no further.
Perfect. I see Stephanie Toothaker. Thank you very much. You have 15 minutes for your presentation. Those individuals associated with your project must speak during your presentation time. Feel free to proceed.
Thank you, Chair. And thank you to the board. Stephanie Toothaker on behalf of the Emke family who is here with many of their neighbors. And we do appreciate the board's giving us an opportunity to defer this item to this evening because it did allow the Emkes to go have conversations with their neighbors, with additional neighbors that hadn't spoken to prior. And we do have some additional letters of support, and we have some neighbors that are here this evening to speak in favor. So the subject property, I know you're familiar with it. It actually fronts 14th Avenue, although the city defines the front as what the Emkes define as their side yard. It is close to Lauderdale Marine Center, so it's very close to an industrial area, although this is a very nice neighborhood. The residence was built before the Emkes purchased it. It was built by a prior owner, so they purchased this home in the exact configuration that the home sits today. And then because they've got a lovely blended family, they added some accompanying structures that many people like to do, like a pool, shade structure, things of that sort. So you can see here, the city defines what you see on the top of your screen as the front yard, although that is technically the side yard, and their address actually, their front address is what you see here on the screen as the side yard. So the zoning setback in this category is the zoning is RS8, and the setback requirements are 25 feet at the front yard. If it's a corner yard, it's 25% of the lot width, but not greater than 25 feet. The side yard is 5 feet, and the minimum rear yard is 5 feet. So I'm going to go back to the prior screen. So that creates a little bit of confusion about what's actually permitted on this site, because as you can see, the city defines what is the front of the house as the side yard, and what we say here on the front yard is technically their side yard. So really the side setback, if that is the side yard, which is how the house is used, because the house faces a different direction, the setback there would only be 5 feet, not 25 is what the city is saying is required. So here you can see where the gazebo sits as it relates to the house. So again, we've annotated the survey here to show you that the city is saying that 18th Court is the front yard, even though that's the side of the house, and that's not where you enter the house. So the code, as applied, requires a setback there of 25 feet, as opposed to 5 feet, as if it was actually the side yard, even though the address dictates that the front faces 14th Avenue, not 18th Court. So the first variance that we're asking for is where the code allows freestanding shade structures to be in the rear yard. And you can see whether it's the front or the side, it's not in the rear yard because the house was built in a way that the pool, which is a permitted structure and completely complies with code, the pool is on, whether you call it the front or the side, the pool is on the north side of the property. The second variance that we are asking for is that the Cheeky Hut is a little bit large for what the code defines. I'm going to stop here and mention, and I know this board has considered many of these. Cheeky huts are permitted to be built by the Miccosukee or Seminole tribe or vendors that represent those tribes. And a lot of times what happens is that because you are not required to obtain a building permit, the tribes are not required to obtain a building permit. A lot of times these cheeky huts go up. There's a misunderstanding of the code. You still have to comply with zoning. But in this case, as happened, and I've represented other of these before, a lot of times the cheeky hut gets built and then the owner realizes, well, yes, I didn't need building permits to do it, but in fact, it unfortunately didn't comply with zoning, which is what happened here. So the Cheeky Hut was built by a proper vendor. It is a certified Seminole tribe Cheeky Hut, but it is, as you know, is not compliant with zoning, but it was a bit of a misunderstanding by the owners. So it is 44 feet bigger than what the code currently permits. One other that is a byproduct of that same situation is that it's slightly higher than what the code permits. The code says that a shade structure, freestanding shade structure can only be 12 feet in height. This one is 14.5, so it's 2.5 feet higher than what the code permits. So that is another variance that we are requesting. Again, actually, I appeared before this board many months ago for a different client, and this code, the code used to say that you couldn't, that the structure had to be open on all four sides. And if you remember, I represented a family that wanted to build an outdoor kitchen, and the board granted that variance. And this board actually sent a communication to the commission saying, we think that's a weird variance. Doesn't everybody want want countertops? And so the city actually changed the code to permit that. So now that doesn't require a variance, but it only permits up to 42 feet. And this particular cheeky hut has one wall that covers one of the sides and actually creates a bit of a sound buffer. But the code only allows it up to 42 feet. So that's the fourth variance. And then just as I discussed, the setback variance it's a little confusing because the city says it's a side yard, a front yard. We consider it to be the side yard, but in any event, we need a variance because it's 2 feet away from the property line. So whether it's a variance of 3 feet or a variance of 23 feet, it depends on your interpretation of what's the front and what's the side. And so here's some images of the cheeky hut. As you can see, it accompanies the pool. The pool, as I said, is completely compliant with code. It conforms in every aspect with the code. And actually, most of the cheeky hut actually conforms with code. It's not that the whole thing is not permitted. There's certain aspects of it that require variances. The cheeky hut is permitted. It's a little bit too high. It's a little bit too big. You can see it was built to accommodate a table on the inside and countertops to hold all the kitchen equipment. And you can see in this image here that there's one wall that's got a television in it, which is the wall that needs a variance. So we did, the neighbor, our direct neighbor, did speak against the project, and we did ask the MKs, you asked the MKs, and I asked the MKs to please go try to speak to the neighbor. Did try to speak to the neighbor, left a note, asked him to call, and it's my understanding, I don't want to speak for him, he's here, but it's my understanding that unfortunately no communication happened between the parties, but the MKs did try to do that. So this is a copy of the letter that was left in their mailbox or at their front door, I believe. So another important aspect, I think, that's very important is the variance. The largest variance is the variance from the property line that's on the north, which is the variance to 2 feet. But there is a massive swale there before you get to the pavement. So, property lines are an interesting thing. You can see them on the surveys, but your eyes don't tell you that's where the property line is. You would assume the property line is at the street, where in fact the property line is much further back because the swale is actually in the public right-of-way. So the actual space between the gazebo, the tiki hut, and the pavement is actually much larger than what the variance request is. It does, and I think this is a really important point, the gazebo does meet the setback requirement on the side adjacent to the neighbor that's objecting. So that neighbor, that is not a variance that we have to request. It's completely consistent with the ULDR on that side. So as I said, it's a cheeky hut that was constructed by the Seminole Tribe of Florida, which is permitted. And I'm just showing you some pictorial images of what those variances are. So you can see here, when you look at the aerial image of the house, you can see that it faces 14th. It does not face 18th, which is why, it's is it a side yard? Is it a front yard? It really doesn't matter. It matters because it's on the side yard. So it forces us to ask that, because the city says it's a front yard, it forces us to ask for a variance that's greater than what you would consider, because to this family it's their side yard, and the proper address of the home is actually on 14th Avenue, not on 18th Court. And here's just some images of the hut itself. And you can see through the hut, you can see it's very densely landscaped, and there's a wall, a privacy wall, so it's very hard to even see it from anywhere outside the property itself. The height, doesn't conflict with the other structures. It doesn't conflict with trees, and and appropriately, I think it is a little higher just because you've got grilling. It's if it was not a cheeky hut structure, I think you could bring the height down, but just for safety reasons, I think you would want it slightly higher. And you can see here the built-in cabinetry, just some images that just shows you exactly what the variance is, and you can see how densely landscaped it is. And of course, here I'm showing you, you can see now how far apart the tiki hut is actually from the pavement, from the right-of-way. These are just neighboring views. It's very, very hard to see from the street even. And just some interior views. And I know you've approved many of these in the past, so I just wanted to show you some examples of some other ones that you've approved. The one on the left was approved 5-0. That came to this board for a variance. The one on the right was actually on the same agenda as us in October. So this was the tiki hut that was right behind us on the agenda that this board approved. It's actually much larger in size than the one that's before you this evening. This is another exterior structure that was previously approved. And here's the subject property outlined in red. And all of the homes that we have highlighted here have letters of support that were sent to, some of them had been sent to you previously and additional ones were sent today, and some of those people are here this evening. So we've just highlighted here each of the individual letters of support. And I know that there are some folks here that would be very happy to speak in favor. We hope that you will approve this variance. We really did try, the family really did try to reach out to their neighbors and make sure that everybody was comfortable. I think you'll hear that the objection is not to the hut itself, it's to this beautiful family back here. And they have a lot of kids. I understand that the children enjoy coming to the home, and maybe there were some concerns about noise, but I know one of the things that the Emke's did is they reached out to their neighbors and said, here's our number, and if it's ever a problem, please reach out to us. We always want to be good neighbors. We want to make sure you're happy and that you have peace and enjoyment in your home, and that we also, can enjoy ours and hope we can all be friends. And I know that's very important to them. So thank you. Does anybody want to, you had said they have to be part of ours. I think they just wanted to speak in favor. Can I have you all stand up, everybody in favor of the variance? And if you're a neighbor, raise your hand if you're a neighbor. Lots of neighbors here.
Perfect.
Okay.
Would you like to reserve some time for?
I would like to reserve some time, yes. I think I have 6 minutes left, so thank you.
Thank you very much.
Thank you.
And Mr. Chairman, I've got a couple of questions, maybe even only one.
I was just about to ask the board if they have any
Not
questions.
sure if it's for Ms. Toothaker or for staff, but it's about the location of freestanding shade structures. Are they allowed only in backyards or in side yards and backyards? What does the code say?
Let me pull it up on my computer real quick.
Okay.
Howard, or Mr. Chair? I just want to disclose, as we're talking on that topic, I think that was a point of my discussion with council today, was when I was looking at an aerial map of the property, I had a hard time discerning, excuse me, which was the front yard, which was the side yard, because I was looking at the aerial map going, oh, there's a pool there, well, there's a hot tub there. And I said, what's that tiki hut there for? And I said, what are we discussing a tiki hut in the front of the house when there's one there? And so I, went through that myself, trying to discern what was the direction of the property and
This board has looked at variances before.
Right.
Where, although the technical zoning code definition of front yard, rear yard, and side yard says one thing, the house is built in a different way. And I think we had one for a garage 2 or 3 months ago, where functionally it would have deprived them of the ability to expand their garage.
And plus my jurisdiction just changed the address of the property.
Won't change it.
Yeah.
Right, won't change it for the zoning code.
Correct.
Right.
Correct.
Actually, do you have the answer?
All right, so I'm going to read it. It says freestanding shade structures such as gazebos, a tiki hut, or a trellis may be permitted when accessory to a residential use in the required rear yard, but no closer than 5 feet from the rear property line.
So I have a question.
And
way
let
that-
me
Oh, I'm sorry, go
explain
ahead.
what yards are.
Oh, okay.
So a front yard is the first 25 feet in this case from the property line inward, all the way to the side yards, side yard property lines. There are no side yards within the front yard. The rear yard is the same thing. It goes from side yard property line to side yard property line. Side yards are in between those 2 yards.
That makes sense.
With the exception of where you've got a side yard setback that also sits in the front yard. If I've got a 5-yard side yard setback, I can't locate something
No,
in my
sir.
front yard within the 5 feet, can
Yeah.
I?
No, it'll go
But,
right to
but
the
that,
property.
and again, there is no side yard within the front yard. And then as far as
It is the extended property line, that's where, that's how we measure it, that's why we are saying it has to be 5 feet. Although it's not a yard, that extended property line from the building line is going to be extended, and that's how it is.
yeah, and it's not talking about a side yard, it's talking about a side yard property line.
I understand. The current orientation of the home, just for the sake of asking, if we wanted to designate that side yard as the front yard, the house would still be non-compliant because they don't have the setback for the front yard setbacks.
And so again, this is Bert Ford with zoning. Zoning doesn't determine the yards. Yards are determined by the person who builds the house.
Exactly, and that's
And
the
we
exact-
don't require that the entrance be in the front yard.
Yeah,
So we didn't determine where the front yard was, that was determined by whoever built the house,
the home builder,
the home builder.
which was
And-
before the
and And the other yard that's abutting the other street isn't a side yard, it's a corner yard. And corner yards have a setback of 25% of the width of the lot, not to exceed 25 feet.
Gotcha. I think the point that I think is important to understand is that the initial home builder utilized those front and side yard setbacks requirements to organize the home initially. And so exactly. And so that kind of forces the hand of any future owner. I mean, we can't really have a discussion about what side or front yard should be because it's been designated.
It is what it is.
Yeah, and benefit has already been derived from that. Do we have any other questions?
I think Howard said he had a few. Did you get them all
He's out. He did it.
Done? One?
He's trying to cut back. Okay,
I'm on a question diet. But I would like to hear from
well,
the adjoining neighbors.
you're always just one step ahead. So I'd like to open this up for public hearing. So if there are any members of the public who wish to speak in chambers on this item, please come to the podium. You'll be asked to state your name and address, and you'll have 3 minutes, and take your time.
From this.
I'm G.L. Franklin. I live at 1417 Southwest 18th Court, the other end of the block. When the house was built, it faced north. Now, address has always been north, on the north side, on 18th Court. This structure that we're talking about is a hurricane hazard. And we don't need that. And we do not need a party house in a family neighborhood. We just don't need that. I come home about 10:30 to 20 minutes to 11 every night, and on the weekends when there's football games, et cetera, I can hear them at my end of the block. I'm at the opposite end of the block. And as far as going to the neighbors and asking, that's bull hockey. They never came to me.
I understand.
So I am totally against having this tiki hut because of the hurricane problems that it will cause. You can see what a good hurricane has done on the West Coast and the middle of Florida. We don't need that here.
I understand. Thank you for your comment.
And their water, they have no place for rainwater to go. The pool is almost on the street. It should never been permitted that way.
I completely understand what you're saying, and while your comments don't necessarily apply directly to the variance at hand, I do see how they do relate.
I'm not an attorney. I'm a hardworking man, and I've lived in that neighborhood since 1962. I'm the oldest person in the block.
I appreciate you coming up. I guess, is there anyone else who'd like to speak? Yeah. But I'm a little worried about getting the line. Yes, please. State your name and your address.
Yes, good evening, everyone. My name is Kira Battle, and I live at 1412 Southwest 19th Street. And I have lived in my neighborhood, our neighborhood, for 45 years. And to be honest with you, I don't recognize any of these people that's living in my neighborhood, so I don't know where they come from. I have two things that have bothered me. Something mentioned by, I think it was you was it you? Okay. You mentioned something about a swale that's very deep. And the only reason it's there is because it catches the water from that house that has no swale. So the house next to that two-story home catches all of that water in their respective swale because there's no swale to go to. It's from the pool down all the way to the street, and it was too pretty to destroy and put a swale, I was told. So when it rains, you can see that water stagnant in that other person's house, yard, I should say yard, and it stays there for a week, week and a half. And the mosquitoes are horrific. And then something else that bothers me, as I said, my house address is 1412 Southwest 19th Street. How can I just go to whoever will change my address to some other address that feels like it would be more beneficial to me? I've never heard of that. I know where the front of that house has always been. So why is it now on another street? I'm going to leave it as a question mark because I don't have an answer. Maybe you can tell me why you can flip addresses to make it more convenient to your issues, whatever they might be. So those are the two things that I am very disappointed in that has not been addressed or has been overlooked. And the noise. I live on the other street, but yeah, the noise is there. There's no doubt about it. So, Merry Christmas, everybody.
I appreciate you coming up, and your comments are duly noted.
Hello, good afternoon. I'm gonna stick to the time this time, sorry. Well, first of all, I would like to make
Address?
you...
Name and address.
Oh, sorry, my name is Derek Fernandez, and I'm the property owner of 1404 Southwest 18th Court.
Mr. Fernandez, before you start, do you want to move back into the record your testimony from the prior hearing?
There you go.
So that it's all still in the record?
Yes, still on the record, and from what Mrs. Toothtaker said, and as you can see from the survey, let's say that the front yard is on 14th Avenue. Do I have then the right to request the partial demolish of the house because it's encroaching the rear yard, if the rear yard is the one on my property line? Because the house is 7 feet away from that yard. It's not 15, as the code says. So there is no way that the front yard is on 14th Avenue. As all the neighbor says, and historically it's been, the front yard is 1400 Southwest 18th Court. This case, it's on the address of 1400 Southwest 18th Court. If you go to the G's property map, property tax, everything, all the addresses are 1400 Southwest 18th Court. They changed the mailbox, which I guess they have the right, I don't know, but that doesn't change the setbacks. And another criteria, which I totally disagree with that, is on the criteria to grant variance. So the section 4724.12, section D, says that the unique hardship is not self-created, variance, special exceptions, and interpretation of the ULDR. Criteria, a variance from the terms of the ULDR shall be granted only upon demonstrating a unique hardship attributable to the land by proving preponderance of evidence of following criteria. Point D, that the unique hardship is not self-created by the applicant or his predecessors, nor is the result of mere disregard for or ignorance of the provisions of the ULDR or antecedent zoning regulations. This house was built in 2008, which we still have the current city ordinances. The owner that built this house maximized the property lot because he wanted a very big house. So maybe he wasn't thinking about putting a pool, tiki hut, a theme park, or a zoo. So I understand that the limits are what they are, and the owners, when they bought the house, should have done the due diligence to determine that that house wouldn't meet their future needs. So we, the neighbors, we don't have to pay for their wrong decisions on purchasing a house or on doing work without permit. So what I'm asking today is to, since this is very controversial, I'm truly asking to please stay neutral, enforce the law, and reject this variance, because as I also sent a document this morning, there's nothing on the applicable rules that apply to this case that are being met. Not the height, not the dimension of the tiki, not the zoning requirements on the side setbacks, side, etc. Plus, another thing that also one of the neighbors mentioned, this property was, in the front yard was, and you can see the pictures, the historical pictures, so to get an idea. The front yard was graded and was raised in the elevation. So the tiki hut is 14.5 feet. But if then we consider the height from the street, that they, so the soil that they raise in their property compared to the street, I believe this tiki hut is even higher. So that's why I also insist to please reject this variance, because our life maybe will be much peaceful.
Actually, hold for 1 second. Is it appropriate for me to ask him his opinion on each of the four? Because I'd like to try to dial in. I mean, you ran through them very quickly, but we've got we've got something built in the front yard. We've got a maximum square feet that's been exceeded. We have a height issue, and then we've got that kitchen wall. And so, I mean, is this kind of a broad brush, like I don't agree with any of these, or is it a scenario where it's like, well, I don't really mind the wall, but the height is an issue, or the height is not an issue, I'm worried about the placement, or
look,
does that matter?
Okay, because I would speak a lot, so to stick to the time limit, as I put also on the record last time, I'm also concerned for the safety that this can cause in case of a hurricane. That's one thing. The second thing is that this is an outdoor kitchen that has gas. Since this structure was not supervised by any code inspectors, we don't really know if it's been installed by code. So we don't really know if it's safe as the Florida Building Code might require.
Has this been permitted? Has there been any permits pulled?
For the tiki hut?
Or for the pool?
Yeah, there is a permit, and it's been closed out for the pool, and it was approved.
But the tiki hut can't get a permit until it either gets a variance
Exactly.
or modifies itself to come into code.
Because what I'm trying to quantify is the grade issue. And so if I'm understanding it correctly, to get the pool coping as part of the permit, the grading would have been part of that. So the grading issue is not related to the tiki hut. But at the same time, I do see where like a potential gas line would. because that would be part of the tiki hut.
Yeah, I don't believe the pool grade has anything to do with the tiki hut.
It's the outdoor kitchen. I was referring that the outdoor kitchen has gas. So since they didn't pull the permit for the outdoor kitchen and for the tiki hut for any of those things, I'm not talking about the pool, we don't really have any certainty that it was installed by code, by a professional, by a licensed contractor.
Point of order, I don't think it's germane for that.
Well, beyond the
itself.
purview of this board at the moment.
Exactly.
Yeah, but I have a question too, just point of information. I'm trying to, and I'm a new guy here, I'm trying to get the definitions down. If it was just a tiki hut right now, is it out of compliance?
Yes.
Yes.
So the addition of kitchen and all the other sundry items is irrelevant.
No, it's an additional variance that they're asking for.
But something that can't go through permitting to determine if it was safely installed or needs to be reinstalled until we solve the variance issue. Because unless they get a variance, it's moot as to whether it was safely installed. It's all got to come out.
There seems to be a lot of
Right.
pieces in the puzzle.
Sure.
But I sent an email to the city, to the Department of Sustainable Department to request the installation of a tiki hut, and they sent me the papers to pull out a permit for that as well.
I missed your question. I'm sorry.
No, that I just want to comment that even the tiki hut structure needs to have a permit to be installed.
Well, certain aspects of it do.
Because I requested this information on the city of Fort Lauderdale, and I was told that I would have to pull out a permit and fill out the information to install a tiki hut. I don't remember which form, but I have the email that
You
I
would
can
need
forward.
a zoning compliance letter, and if you had things that were not, and correct me if I'm wrong, if you had things that were not part of a standard tiki hut, electricity, gas.
Yes, those were other.
Those would need a permit. But
correct.
for just a tribally installed tiki hut, you'd need a zoning compliance letter, right?
All right, so just to clarify again, Bert was zoning, to clarify the difference between a chicky hut and a tiki hut. What they have is not a chicky hut. A chicky hut is just the structure, completely open, built by a tribesman.
With the thatched roof.
That, and a structure can have the thatch roof too. It has nothing in it, there's no electricity, no plumbing, no nothing. That's a chicky hut. Once you install anything, cabinets, plumbing, electrical, gas, now even the structure has to be permitted. It's no longer a chicky hut. It has to be structurally, we have to have signed and sealed drawings for the actual structure itself, as well as sub-permits for all the trades.
Which maybe speaks to the hurricane concerns of, that we've heard, where that's where that would be taken into account.
And in order for us to, approve any permit, which there has been a permit submitted, it failed because it's not in compliance with ULDR. And, those signed and sealed drawings would have to show compliance with the 2020 Florida Building Code, as well as the ASCE wind load code.
But you can't review those until we get past the variance issue.
And so the
Basically.
theory
We
is,
reviewed it, it failed for not being in compliance with ULDR.
Yeah.
So,
and never even got to
but
building
in order to
code.
pass, ultimately, it will have to be approved through all the Florida Building Code
So
requirements.
in theory, if granted the variances, they would still be required to clear the hurdle of building code.
Of the permits, right?
That's correct.
Thank you very much.
Thank you. Can I say just one last thing? Yes, even if they, this is not a battle against one neighbor or the other. For me, it's a battle of following the rule of law, which is the ULDR and all the applicable codes, or not following it. So accepting this variant for me would be going totally against the law. So that's the reason why I don't want to, so when all the problems with the noise came up here, I speak to them, and as the Mr. Two-Taker says, Derek or whoever can come to us and say, hey, this is what happened. But I'm not going to call somebody at 2 a.m. because they awake me. I truly believe in self-responsibility from people. So I don't want to police anybody. I just want to live peacefully, which is on my property bill of rights. And the reason why I didn't reply to that letter is because, first, of course, I don't want to have anything with them. Secondly, words are totally worthless. And I'm so sorry to say, I'm very stoic. I only believe on people's actions, not on people's words. And unfortunately, the words were totally different than the actions. Thank you.
I understand, thank you. So, are there any other members of the public that would like to speak?
We should have thought of that 4 speakers ago.
No problem. Good afternoon. This is Joaquin Fernandez. I live in another neighborhood. I spoke.
I'm sorry, sir. Can you actually put an address in for the record?
The address 1221 Northeast 16 Terrace.
Perfect. Thank you.
As I said the other day, I'm an architect, licensed here in Florida. Also, I was the architect of Derek Fernandez. He's a personal friend. I only to puntualize here because I don't like to see how to try to defend or to say, to justify about the setbacks and everything, because when you maybe it's demonstrated that you don't know how to interpret the code, because the front yard is defined. Base building line is when you have to take your setbacks in the front yard, wherever it goes, 25 feet from the front setback is from the base building line, not from the corner of the road or the right of the way. This is not in the right interpretation, and probably everyone knows, but wants to change that to try to get the room to see is inside. So that tiki hut or whatever is actually, for me, is actually a building, is in the front setback, facing 3 feet from the base building line. This is how the setback has to be interpreted in the right project to be approved in the city. There are no confusions, so say there are many confusion because it's the corner lot, it's a corner lot, front setback, street setback, and side setback. This is pretty clear. The code says everything, and every architect can follow the rules easily. Also, the house was built in the front setback facing 18 court. So it's not changing, it was approved, was built, and the front setback from the beginning was there. This is only to puntualize, and yeah. And the height also, Derek says, I personally walking there many times. I see how the ground level raised almost 2 feet from the floor finish elevation from the street. That creates also a triangle visible issue in the corner of the property. The pool is there. All the pavement is 2 feet high minimum, plus the construction. So only to clarify that.
And so in theory, if we were to grant these variances, those would be additional issues that they would have to handle at a building code level.
Dwayne Spence, Assistant City Attorney. No.
No.
So the variance request is to seek variances of 2 code sections. One has 4 provisions, one has 1 provision, but it is consistent with staff's interpretation of the code. I believe that the applicant's attorney mentioned the street and the street orientation of the structure and trying to argue their point of how their variance request meets the intent of the code. But the actual variance requests are seeking requests that staff has stated is required by our code. So this front yard, the very first request that you have, is for a variance from the provision preventing such freestanding shade structures from being located in the front yard, whereas the presentation was that you should view it as a side yard, but they are seeking a variance from treating it as a front yard. So this is not ask for a change in interpretation of our code. It is a direct request for a variance from the provisions of the code as interpreted by staff.
And Mr. City Attorney, and the numerical variance request, the actual footage or distance, are distances and footage that staff agrees is the appropriate distance for the variance.
That is correct. If the variances are not granted, the structure would not be permitted. And so the numerical values are the distance per how staff interprets the code, not as the applicant is putting forth the orientation of their home. And I'd like to state also for the record that the consideration here is all locational based, and that the board is, based on our code, required to, well, the applicant has the burden of proving by preponderance of the evidence that they meet the 5 criteria for granting a variance. And your job here is to look and take in the testimony and determine whether or not they've met that burden.
I understand. My concern was really based on the secondary issues that they may encounter if we were to grant this variance. And I just wanted to make sure that I addressed some of the comments from the public and make sure that they understood how those comments are integrated into the overall.
Certainly. So in addressing the location of the freestanding structure, your board is determining whether or not they meet the criteria for granting a variance. Once that is done, the other regulatory arms of the city comes into play. They already have been tagged for the structure. They will not be issued a building permit if the plans and so forth do not meet code. And there will be inspections, even though it's an after the fact. There will be inspections to ensure compliance with our building code for that structure.
And specifically what I heard was wind associated with hurricane, impervious area, and then grading relative to the property line. So each of those would be picked up on a secondary thing if this was approved.
Correct, through the building permit process.
Perfect.
But the purview of the board here
Thank you.
is the location of the structure
That's what
per
we're
our
doing today.
ULDR.
I completely understand. Are there any other members of the public? That bench is empty? Anyone? Okay, well then.
Mr. Chairman, while Ms. Toothaker is coming to the board, I do have one question for Mr. Kent. Are you regretting your decision yet to serve on the board?
You got anything to say?
I don't have anything to say.
Okay. Wise man. The floor is yours.
Thank you. I just wanted to make it clear, we did follow the direction of staff, so the variances that are before you are the variances that staff defined what we consider to be our side yard as our front yard. So that's the variance that is before you this evening.
For this step.
For this step, we met with staff, we agreed on the variances that they felt we needed to ask for. Those are the ones that we are asking for. I just wanted you to see that the orientation of the house, it's one of the quirky things in the code. I also want to be clear that the permits have all been applied for, but appropriately, the building department put everything on hold pending this hearing. And so if you were to grant this variance, we would continue with those building permit reviews. And if anything were to come up, impervious area, hurricane, anything like that, structural integrity, all of those would be vetted through the building department as is appropriate. And I also want to be clear that a tiki hut's permitted. It's a permitted use. You see them all over the city of Fort Lauderdale. It's not that this is not a permitted structure, and in fact, even the kitchen area, all of that is all permitted use. It's just that it's a little too high, it's a little too close. Whether you define it as the front or the side, it's a little too close. It conforms with the setback on the side adjacent to the neighbor. So that, even if we were to take it down by 2.5 feet, skinny it up by the 44 feet in size, the structure, and comply with the setback, we could still have most of what's out there. It's just not, we're asking and apologetically asking for the after the fact right to keep what's there. I think the MKs are very aware. They, wish it had been done differently, a little bit of a misunderstanding, and are really asking for this board's understanding, and really did try very hard to be good neighbors, and I know, and strive to continue to be good neighbors. I am going to ask Governor Stamper to just come up for a minute. That concludes my comments. Thank you.
Good evening. I'm Scott Stamper. I'm at 1425 Southwest 19th Street. I am a neighbor on the opposite corner to the Emkes, and I built that home there in 2006. I'm a Broward County resident since 1986, and can tell you that they're a very lovely family, and what they've done with the property has greatly enhanced the beauty and value of the property. I can also support that they have a very, very lovely, welcoming family. The home was originally built by John Shearer of Gulf Building, which is probably familiar, not unfamiliar to many of you. And I was friends with John Shearer, remained friends with John Shearer, who lived in the home as it was originally built. I don't really understand the controversy with respect to front and side, because the home has always been utilized as a front door on 14th Avenue. It's always been used like that. So
It's fun.
that-
We
that's-
understand.
That's been the way that they use the home. It's the way the home's being used now. I've been in and out of the home when John Shearer owned the home, and have been invited on many occasions, some of which I did accept, to come over for various celebrations and things at the house. Yes, they have a family of teenagers and a lot of people in the neighborhood that they've invited to enjoy their home. Many of the neighbors I've met by participating in the activities at their home. So it's a lovely structure. I'm not going to get into the particulars. I'm not an architect. I don't know the code violations that may be in front of you, other than to say that my home, their home, our neighborhood doesn't have flooding issues. There's no issues with respect to, the water doesn't stand in the street in front of their house. It doesn't stand in front of the street in my house. There are a lot of other areas in the city of Fort Lauderdale that have flooding issues, but it certainly doesn't affect that property or my property to any degree greater than anywhere else in the city of Fort Lauderdale. So I appreciate your time and consideration, and hopefully you'll be able to grant the variances that are before you.
Thank you.
Thank you.
Okay, so at this point, I'd like to close the public hearing.
And Mr. Chairman, I have one question for Ms. Toothaker.
I was just about to ask if the board has any questions for the applicant or staff.
Ms. Toothaker, you have 5 variance requests before this board.
Yes.
Would you like them to be heard individually or as a group?
I think it's probably not relevant, because if one of them is not granted, the tiki hut comes down.
Got to come down.
Yeah,
Okay.
but thank you.
You just cut our time by 80%.
Thank you for asking.
Mr. Chair, I do disagree with that slightly. While I agree there is a cheeky hut and a tiki hut differential, there are 4 of these provisions that are basically, in my mind, associated with the construction of the cheeky hut by an Indian tribe, which ultimately we have afforded them here in South Florida to do in order to help them and their tribe and their business and to make more money. One of these, which is with regards to the kitchen and the structure with regards to, being enclosed partially or not, has nothing to do with the cheeky hut tribe.
I wasn't saying it did. I just asked her if she wanted us to do it in one motion. They either all fail
Correct.
or live, or by 5 individuals.
I am asking the chair to consider another option here. I understand what the applicant wants, but I think there are essentially 2 differing variances, in my opinion. One with regards to the structure and its location, and another regarding, what's in the inside of that.
I hear what you're saying, and I'd like to speak to your core point, which is, it sounds like you want to give a little more flexibility to things that were built by the tribe, lack of a better term.
It's why the process is the way it is, and if the tribe builds it that way,
I completely
I
understand.
don't believe that the intent was for the city of Fort Lauderdale to come in and tear down something that the tribe has created.
But they still built it illegally.
So, Assistant City Attorney, if I may help you here, You would have to take each of the sections separately in your consideration. I think the question as to whether or not you should take the individual provisions in section 4719-2P is at your discretion, and I believe the applicant is saying that they need all of those to be passed, but I would advise that the board consider 47-19-2P separately from 47-5.31.
Yeah, 0.31.
Oh, man, you're going to have to bear with me. You lost me there right at the end.
We're
So,
breaking them into two groups.
okay, and then so how do we differentiate between the groups?
Based on code sections. So in the bold,
Oh, I see it.
bold and underlined is the code section that each of those bullet point requests are associated.
So 4719-2P and 47-531 would be two separate.
Correct.
I got you. That totally makes sense. Ms. Toothaker, do you have any other questions? I mean, I guess.
I don't. I defer to the board. Thank you.
Thank you. And, all righty, so with no more questions to the board or the staff, and I guess the board, do we have any more comments?
I just still think we should take each one individually and not do them as even just the two. Because the one provision I'm talking about is in the first one of the four. It's not separated out as the fifth one. So I think individually,
I don't necessarily mind. I mean, as long as it's not illegal.
No, I'm hearing that, but I'm also hearing the member kind of suggest that it's a question of interpretation. Staff has determined that
This is how they block
the
out.
cheeky hut does not meet the exemptions under Florida statute because of the electrical work. The applicant has submitted their application bearing that in mind.
Gotcha.
So for the board to take the prerogative to attempt at this time to do a separate interpretation of the code, I think goes beyond the scope of both the application and staff's determination at this point.
I understand. I'll accept the interpretation from the Assistant City Attorney. And so.
Well, Mr. Chairman, I'd be happy to make some motions, and if we want to change them while they're out there, we can do that. So I'm going to make it in two different pieces. And I'm going to move to approve the 4-point variances requested under section 47-19 or 47-19.2P freestanding shade structures because they meet the requirements for variances under the city code.
I second that.
Please call the roll.
Yes.
yes.
Mr. Nelson?
Yes.
Mr. Wolf?
Yes.
Mr. Elfman?
Yes.
And Chair McGinley?
No.
Motion passes.
Pass 5-1.
My second motion is with respect to the variance requested under section 47-5.31, the dimensional requirements, is that we grant a variance because the request meets the requirements under the City of Fort Lauderdale Code.
Second.
Please call the roll.
Mr. Maxey?
Yes.
Mr. Nelson?
Yes.
Mr. Wolf?
Yes.
Mr. Elfman?
Yes.
Mr. Kent?
Yes.
And Chair McGinley?
No.
Pass 5-1.
All right. So, so it's passed. All righty.
But the,
That was easy enough.
but the cure is to still, we're gonna have to go back and do permits.
All righty. So,
Have a, yeah, we have.
so do we want to take up the calendar question? Do we have that?
So it's scheduled as item number 7
Yeah,
on the
it's part of the
agenda. So
agenda.
if you have any communications at this time.
Yep,
If you just wanted to follow the agenda.
yeah, but
Hold on for 1 second. So we have all our board members pay attention.
I'm sorry, sir. Yeah. Thank you, Howard. Hey. I'm sorry, so where would the calendar fall in?
The calendar vote is listed as item number 7 on the agenda.
Oh, okay.
So if you just would like to go with communications to the city commission at this time, it's on the second page of the agenda, item number 5.
I don't, yeah, for whatever reason, that's not on.
Mr. Chair, I move agenda item 7.
Oh,
We
okay.
take it up immediately,
Okay.
dispense with it.
Second.
Can we do a verbal? For all those in favor, say aye.
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 All those opposed, say nay. All righty. And I guess, I'm so sorry. Yeah, I'm so sorry, we're done. And then, that was the communications to the city commission. Does anyone have anything to share for the good of the city? All right, seeing no further business, we'll entertain a motion to adjourn.
So moved.
Happy holidays.
Happy holidays, Merry Christmas.
Chair, did we vote it on the calendar?
I'm not sure if we voted on the calendar.
I'm sorry, I think we ordered.